Welcome. Good afternoon. I'm so excited to see what a great turnout here for this important panel discussion. I'm struck by the fact that yesterday we had an election. I hope everybody voted either yesterday or earlier. And the election will determine, it is still not determined, who will control the legislative branch of our federal government. But of course, even while that is undecided, the judicial branch of our government moves forward, and specifically the Supreme Court continues to hear cases. And last week, the court heard cases in two very important cases involving Harvard University and the University of North Carolina. And we thought it very important to bring these issues to you to have a discussion about the issue of affirmative action and its constitutionality and its wisdom. And we have expert panelists who will be introduced shortly. But I have the privilege of introducing our moderator. And she is a friend, and this is a homecoming for our friend Jill Green. So I want to make sure I get Jill's title right. So I'm going to pull out the piece of paper. Jill is currently at the Johns Hopkins Carey School of Business, where she is the Associate Dean for Education and Student Experience. Her portfolio there includes admissions, student recruitment, academic programs, and efforts to promote diversity, equity, inclusion, and belonging. So she herself has thought deeply about the issue of affirmative action in higher education. As I say, this is a homecoming for Jill because she is not only a 1994 graduate of our law school, but she served as our Assistant Dean for Career Development for many years and did a fabulous job in that role. We were very sorry when Johns Hopkins stole her away from us. But as I say, we're so glad to have her back. We're proud of the work that she's doing now at Hopkins. I'm glad that she's at a business school and not a law school where she would be competing with us. But she is very well suited to narrate this important discussion. So I give you our moderator, Jill Green.
Thank you, Ron, so much. It's good to be home. I love this space. I love this place and what UB is and does. Congratulations to all of you that are currently here at UB. You joined an amazing institution and a really esteemed group of alumni. Many of them are working here with you right now. So thanks so much. And I'm really excited to be here and to join this distinguished panel in examining the issue of affirmative action in higher education admissions. Specifically, the two cases that were argued before the Supreme Court. The case Students for Fair Admissions versus the President and Fellows of Harvard College asks whether Harvard violates the Civil Rights Act because Asian Americans are less likely to be admitted than similarly qualified white, Black, or Hispanic applicants. The case Students for Fair Admissions versus University of North Carolina examines whether the University of North Carolina violates the 14th Amendment's Equal Protection Clause by considering race in its admissions when, according to the plaintiffs, it does not need to do so to achieve a diverse student body. Here to explore the nuances of these cases and really help us understand the issues are three professors from UB School of Law and a wonderful guest and colleague from George Mason, Antonin Scalia School of Law. Professor Greg Dolan has been on the faculty of UB since 2011 and teaches intellectual property law, torts, and contracts. He serves as an appellate counsel for the Jewish Coalition for Religious Liberty, an organization dedicated to preserving the ability of individuals to freely practice their religion without undue government interference. In this capacity, he has authored and co-authored numerous briefs before the U.S. Supreme Court and courts of appeals. He's also a member of the Federalist Society's Administrative Law Regulation Practice Group Executive Committee, is an adjunct scholar at the Cato Institute's Robert A. Levy Center for Constitutional Studies. To his right is Professor Mike Higginbotham, who is the Joseph Curtis Professor of...
My left. The other right.
Is the Joseph Curtis Professor of Law at UBOT Law, and he has been on our faculty since 1988 and teaches constitutional law, race law, and human rights law. He authored and noted the noted casebook, Race Law Cases, Commentary and Questions, as well as Ghosts of Jim Crow, Ending Racism in Post-Racial America. Professor Higginbotham is also the co-founder of the Fanny Angelos program here at the University of Baltimore School of Law, and also served as the former interim dean at the law school. I had the pleasure of serving with him. Professor Sheldon Bernard-Like joined the faculty of UB in 2020 and teaches critical race theory, property, trust, and estates. His scholarship focuses on anti-discrimination laws regarding racial and sexual minorities in the comparative context. His current research explores anti-affirmative action practices in higher education. His article, Offense Against the Dark Arts, How to Fight for Affirmative Action After SFFA versus Harvard, is forthcoming in the Washington and Lee Law Review. And our special guest this afternoon is Professor David Bernstein, a university professor and the executive director of the Liberty and Law Center at the Antonin Scalia School in Arlington, Virginia, where he's been teaching since 1995. He teaches constitutional law, evidence, torts, and products liability. He's the author of 5 books, including this year's Classified, The Untold Story of Racial Classification in America. He's here. He can sign your book if you brought it with you. Which argues that in an increasingly diverse society with high rates of intergroup marriage, the American system of racial classification is becoming even more arbitrary and absurd. With rising ethno-nationalism threatening democracy around the world, it's also dangerous, he says, and argues that the time has come to consider abolishing official racial classification and replace it with the separation of race and state. With that, let's dig in and begin our discussion. We'll have an opportunity for questions at the end. So I'd like to start by inviting our panelists each to share their view and take on the current cases before the Supreme Court, the overall issues from their perspectives, and we'll ask Sheldon to really kick us off and include a little bit of historical background on the relevant cases of affirmative action in higher education admissions.
Absolutely. Okay, so I think that the overall question is organizing this conversation is, should race be used in admissions, correct? Isn't it, Joe?
Is that a question to me or the audience?
To you, no, to you particularly, right. And so I just wanted to, I guess, preface this whole thing and say that I actually don't think that race should be used in admissions. But unfortunately, it is, and that's outside of affirmative action. And we can really think about affirmative action more as a check on the ways in which universities have been using race in admissions for the last 100 years. When we look at the different criteria that they use, like undergraduate, like GPA, standardized testing, letters of recommendation. These are all things that have been empirically proven and shown to have racial bias in them. So in many ways, affirmative action is not, at least one of the things that I argue, is that affirmative action is not the introduction of race into admissions, but it's actually a way of counterbalancing the ways in which race have already been used in order to create a sort of a net zero racial discrimination by universities. And one of the things that I argue in my work is that advocates of affirmative action have been kind of sort of fighting this fight for affirmative action in the wrong way. They have always put up a defense strategy. So the way that these cases normally work is that you get someone like Michael DeFunis, Alan Bakke. So Michael DeFunis was the plaintiff in the university, the very first affirmative action case that went before the University of Washington School of Law, where they had 2 separate admissions policies, those for underrepresented minorities and for white students. Michael DeFunis said that this was unconstitutional under the 14th Amendment, Equal Protection Clause, and and the University of Washington basically went through the whole process saying, okay, well, there's all sorts of reasons why we need to have affirmative action that includes getting more minority lawyers into the profession. The court never reached the merits on that case because by the time it got to the court, Alan Bakke was graduating from law school. So the court basically said that the issue was moot. And the first time that we actually get the court deciding the case on the merits is the case with Alan Bakke in the University of California, where he applied to University of California Davis Medical School. And they had a set-aside program where there were 16 slots that were held for minority students. Alan Bakke said that this was an impermissible quota. The University of California said, well, there's all sorts of reasons why we need affirmative action because we want to get more Black and brown folks into the medical profession. We want, and also to have a more diverse educational product because the idea is that the more diverse students we have, the better education we can provide for those students. The court in that case basically disagreed with the University of California and said that you cannot remedy societal discrimination, that you can't, their goal for trying to get more Black and brown medical students was an attempt to fix racial disparities that were broad in society. And the court basically said that you can't do that. But what the court did say, in a plurality opinion by Justice Powell, was that, but you can use race if you want to create a more diverse class. But only one justice signed on to that portion of Justice Powell. Well, Justice Powell was the only person who advanced that notion. No other justice joined in that portion of his opinion. And then 25 years, that was in 1978. And then 25 years later, the case comes back before the court in 2003 in the Michigan affirmative action cases of Grutter and Gratz. One was undergraduate case, the Gratz case, and the Grutter case was the law school case. Two different programs. The law school used a holistic review process where points were not assigned to race, whereas in Gratz, points were assigned to someone based on their race. And it ended up that I think the points for being Black or Latino ended up being as high, if not higher, than someone who would receive a perfect SAT score. The court in Gratz basically held that that's an impermissible quota because the points were so heavy, race was so heavily weighed that served as an impermissible quota. It was mechanical. But the court did allow for the university's, the law school's admissions program that used race amongst a number of different factors. So race did not count too much or too heavily. And the court in Grutter, because the plaintiff in that case was Barbara Grutter, held that, with 5 justices, held that diversity was a compelling government interest, and as long as it's narrowly tailored, using this holistic review, that it was permissible, okay? That case ends up getting challenged once again. Affirmative action ends up getting challenged again in the Fisher 1 and Fisher 2 cases in 2015 and 16. And in those cases, we have Abigail Fisher, which some people referred to at the time as Becky with the bad grades. And this was a situation where University of Texas had a 10% program that was getting in a lot of students of color, a lot of minority students. And what the petitioners, the lawyers for Abigail Fisher argued was that, hey, actually there's a race neutral alternative that's here, the 10% plan. And the 10% plan basically would allow anyone from the top 10% of their high school class would get automatic admission into the University of Texas. The University of Texas, however, still wanted to use race as a factor because they were saying, well, yes, they were getting lots of students under the Texas 10% program, but only those students who went to schools in disadvantaged communities, schools that were predominantly Black and in poor communities. And that they wanted some form of diversity amongst Black and Latino students. So they wanted to also get more affluent Black and brown students as well. And so the court basically ends up agreeing with the University of Texas and says that they can use race, and again, in this limited way. In the case that we have before us, Students for Fair Admissions is taking a very different slant and saying that individuals of Asian descent are being discriminated against because of these affirmative action programs, these race-based affirmative action programs. And this is where we are right now with the case. The only thing that I would, and we'll get into this, I'm sure, but I want to leave time for my colleagues. That's really important to me is to note, and for me to repeat this, even if we were to end affirmative action programs as we see it today, don't think for one moment that race is not being used in the admissions process. Now, this is not the argument that's being advanced by by universities. Universities are using this argument that we need to use affirmative action in order to have a diverse student body. I argue that actually there's a better rationale than thinking about diversity, that there's an equality rationale. We need to have affirmative action because it is fair, because the system that we currently have is racially biased against Black and brown students because of racial bias in standardized testing, because of racial bias that's been found in letters of recommendation, because of racial bias that comes from grading at the high school, elementary school, college, law school level. These things are real, they are documented, and I think it's a much stronger and better rationale for affirmative action than the one that we're seeing being argued over in the court today.
Yes, up to this current date and for providing that important perspective, going really beyond whether or not diversity is a compelling interest, but to suggest that there are other compelling reasons why affirmative action is important. Turning to Professor Dolan, could you share with us your perspective on the current cases and the jurisprudence up to this point?
Sure. Thank you for having me, and Jill, welcome back. What I want to do, instead of kind of beginning with a perspective, because I think we'll have some time for both Q&A and exchange, and I want to spend a little bit my 5 minutes talking about the argument itself and how it went, and kind of on what sort of struck me between between the petitioners and the respondents. So the argument, I've sat and listened through 5 hours of argument, which is unusual. The cases should have been an hour-long case, as are most cases. This case were initially consolidated. It was supposed to be a single argument. When Justice Jackson got confirmed, she recused herself from the Harvard case because she used to sit on the Harvard board, which then caused the court to deconsolidate the case so she can participate in at least one of them. So she sat on the UNC case, but not on a Harvard case, which immediately moved the case from 1 hour to at least 2 hours worth of argument. And then there were interveners who got their own time to argue. And so UNC ended up, I think, being 2 hours and 45 minutes. And Harvard case was like an hour and 55 minutes. So it was a long argument. I have no idea how justices managed to do it with very short 10-minute bathroom break. But I must say, so after having listened to 5 hours of the argument, it was entirely unedifying. I don't think it was a particularly good argument in terms of, there was very little discussion of, I guess, the law. There was lots of discussion of the facts of the particular program that Harvard was using. But some interesting nuggets came out. And so kind of, I just want to sort of highlight some of them. What sort of struck me as odd, and what also kind of, I think, sort of strengths and weaknesses of people's argument. I think on the university side, the biggest, I think, challenge for the universities, both in this case and previously in Fisher and previously in Grutter and Gratz, et cetera, is that universities are never able to tell the court, and now it's a more conservative court than decided, Gratz and Grutter, more skeptical of race-based programs of any kind. They're never able to tell the court, what do they mean, like, what do they mean by diversity? So for example, in Gratz and Grutter, one of the arguments, or one of the kind of criteria that was being used is this notion of, what was it? Some appreciable mass, critical mass, but nobody was able to say, like, well, is it 5%? Is it 10%? Is it 25%? Critical mass of which subsection? The critical mass of overall non-whites? Is critical mass of just African Americans? So nobody was able to say what that is. And that sort of continues to this day. And so what a lot
We're
of
being asked to speak up a little bit and maybe lean into
and
the
so
mic.
So, when judges, for example, kept asking Harvard or UNC the question, when do you foresee this ending, right? When will you reach the point that you will have met your diversity goals, right? They were never able to answer it. And I think that is ultimately going to be problematic for the court. On the other side, what I think was somewhat problematic for the petitioner is that they were struggling with answering also some interesting hypotheticals. For example, Justice Kavanaugh asked, okay, well, suppose we don't use race, and instead we're going to use race blind, but essentially almost a perfect proxy for race. Say like, look, what about programs meant to help descendants of slaves? Given who was enslaved in America, right? That would be almost uniquely African Americans who will benefit. Maybe some children of mixed marriages, et cetera, but almost uniquely will be Black applicants. And the petitioners were never able to answer whether it is a race-based classification because it so perfectly aligns, or is it not? And if it is or it isn't, like how does it square with the Freedmen's Bureau that was meant to help the freed slaves, which of course also mapped on nearly one-to-one to race. There were some interesting questions raised, some questions that I did not understand. For example, Justice Thomas asked the question, he's like, I don't understand how diversity necessarily helps you learn. Says like, what, because I don't understand what you mean by diversity and like on what scale. And I thought that was a little odd. I guess I could see his point if he's talking about learning organic chemistry. In some sense, it doesn't really matter who's sitting next to you. It's complicated. Molecules only fit the way they fit. But I imagine it very much matters who sits next to you when you learn, philosophy, or when you learn literature, or when you learn law, for that matter, right? So I was a little confused by Justice Thomas's question, although I'm pretty sure I know, given his prior writing, I'm pretty sure I know how he's going to decide this case. It's no great mystery. The other kind of issue that I was sort of surprised on is, maybe not surprised, but it was interesting that it sort of came out. And I think this is kind of the last point I'll make, is that Harvard's history of using holistic review is actually pretty sordid, because it didn't start out to help African Americans. Harvard's history of using holistic review of applicants started out to keep the Jews out. Harvard in the 1920s and 30s, when kind of the Jewish children of the immigrants from the 1800s became of college age, they started applying, and a number of Jewish attendees to Columbia University shot up drastically. And Harvard president at the time pretty explicitly said, we don't want to be Columbia, because if we have too many Jews, it will convince our people, the Boston, blue bloods, from attending university, and we don't want to lose them. And so he tried to actually put a hard quota. And interestingly enough, the faculty said, we can't do this. So as an alternative, it became, okay, well, but then instead of looking at just the grades and admission scores, let's look holistically. Let's look at, for example, geographic diversity. Let's start recruiting people from North Dakota. And guess who doesn't live in North Dakota, by and large, right? So, and that history, interestingly enough, came out in the argument. Obviously, Harvard is using the same, not the same, I mean, the process of holistic review for very different ends now. But this discussion occurred between, I believe, Justice Gorsuch and Seth Waxman, who argued for Harvard, and whether or not we should trust Harvard given its history of trying to keep the Jews out. And basically the question is, are they now trying to basically do the same thing to Asians? So I think there was a lot of skepticism. I'm not sure, for example, if the court says no race, what are they going to do in terms of race neutral alternative? Is descendants of slave race neutral or not? I think it's a very much open question. But I wouldn't necessarily call the case a completely foregone conclusion. Maybe a foregone conclusion saying that these two programs are a no-go, but it's not necessarily obvious to me what the court is going to do exactly kind of on the back end. What is a go?
Greg, David, turning to you, replacing racial classification with the separation of race and state.
Thank you. I'm not going to talk too much about, there is relevance to the argument. I do want to focus mostly on my own impressions of the argument, and we could get into a broader discussion later. But before I get to that, I actually want to praise and thank UB for holding this panel. Back when I first graduated law school, a certain DC-based law school, which is also very close to the local Amtrak station, held a panel on the Clarence Thomas nomination. They promised diverse perspectives on the nomination, and the diverse perspectives were they had two panelists who were opposed to Clarence Thomas's nomination and thought he was like one of the worst people to ever roam the earth, and two people who opposed his nomination but didn't quite think he was the worst person to ever roam the earth. And too many law school panels are like that. So I appreciate the attempt to have different perspectives. So looking at the listening to and reading I didn't have the patience to listen to the whole 5.5 hours, but I did read them. Greg mentioned a couple of things I was going to mention, but I have some others, other things that I noticed that I thought I'd point out. One thing was I thought at least 7 justices, including the 6 conservatives and Justice Kagan, seemed to converge on the idea that given that the Supreme Court has consistently required strict scrutiny for racial classifications, which means they have to be narrowly tailored to serve a compelling government interest, that universities are really required to seriously consider and to some extent actually implement non-racial alternatives, non-race-based alternatives before they turn explicitly to race. So for example, a lot of back and forth about the fact that studies showed at Harvard, if they eliminated their alumni preferences, that would add to diversity, but they don't want to do that. And I think there was a convergence on the idea like, well, before you use race, wouldn't that be something that you should do? It won't really change the institution in any meaningful way other than people are less likely to donate money, but you already have $45 billion endowment, so who cares? In any event, I think that if the court were the court of 20 years ago, where you still had O'Connor and Kennedy on the court, I could imagine the court converging on maybe even a unanimous opinion, as they did in the first Fisher case along those lines, that what Harvard is doing, for example, is illegal because they did not really consider race neutral alternatives at all in a meaningful way until they got sued, and they were ignoring us this whole time. But I don't expect that now, or an opinion. And of course, one reason is the court is more conservative. But I think also the conservatives, when they were asking questions, they gave the clear impression that they think that Harvard, UNC, and similarly situated schools have just been consistently cheating. And the court keeps coming back and saying, okay, you could use race in this limited way for diversity purposes, but you really have to consider race neutral alternatives and so forth. And every admissions office in the country seems to interpret that as the Supreme Court has said we could do whatever we want as long as we don't use quotas, which is not what the court said. And I don't think that the current majority also is as inclined to trust the university. I mean, the Supreme Court is in the small C sense, a very conservative institution. The justices, all but one, went to Harvard or Yale. They're part of the establishment. And I think in the past, Justice Powell said, oh, well, Harvard, and it's in their amicus brief, which I rely on, says they do it this way, we should trust them. And O'Connor says, well, the military and the universities, the big companies all tell us we should act, that they need this, so we should trust them. I don't think there's that level of trust among the current conservative majority. They're not as tied in with the establishment. The Federal Society has been very successful in a pulling sense of pulling the justices into a counter establishment, but they've also been pushed away. To give you the example of Justice Kavanaugh, he used to very establishment guy. He was George Bush's personal secretary, basically. This is second George Bush as president. This is not someone who's a radical flamethrower. You don't get that kind of position. But he used to teach at Harvard, and then when allegations of sexual assault that frankly had never been substantiated were made against him during the nomination process, he lost that gig and actually now teaches at my law school. So he's not tied to that establishment in the way he used to be. Another thing that I noticed is I thought it was a terrible decision by especially UNC's lawyer and to some extent Harvard's lawyer to argue that race is never dispositive, and then also argue, but if we weren't allowed to use race, that diversity at our school would plummet. That's mathematically impossible. It's double talk. The justices didn't like it. Obviously, they were using dispositive to mean that's the only factor we consider, but that's not what the word dispositive actually means. The court also, now this is where we get to the theme of classified my book, the court was much more interested, it has been in previous cases, regarding whether the classifications used by the schools are really coherent and are actually diversity enhancing. In particular, Justice Alito asked UNC's attorney, well, someone checks the Asian box, but then they say, well, I'm from Afghanistan. You don't really have any people from Afghanistan. So wouldn't I be adding to diversity? And then Harvard says, no, you're Asian. And why would someone from Afghanistan accept the fact that, by the way, Afghanistan actually is considered white officially, although you wouldn't know that from the Common App. So he just shows how confusing these classifications could be. But anyway, he made the point, well, why should someone from Afghanistan accept the fact that because you have students from China and Vietnam and the Philippines, that somehow I don't add to diversity because I happen to be from Afghanistan? So that was sort of a new thing. Justice Kavanaugh, meanwhile, asked, well, what about Middle Eastern students? What box are they supposed to check? And there is actually a right answer to that. They're officially considered to be white. It even says on the Common App, I know because my daughter's a high school senior, that if you check white, are you of European origin or are you of Middle Eastern origin? So clearly the Common App says you're white. And I think Justice Kavanaugh was trying to get to the point that, well, a lot of people would consider at least some Middle Easterners to be people of color who would add to diversity, but the universities don't officially consider them as such. But UNC's attorney at least purported not to know what classification that Middle Easterners come into, which I thought was a little weird. More generally, there's been a real shift from the Bakke case in 1978 till today. In Bakke, the 16 slots that were reserved for minority students were actually mostly taken up by Hispanic, or actually they didn't have the Hispanic term then, Chicano and Asian American students. But nevertheless, the debate in the Supreme Court and in the public, and I'm just barely old enough to sort of remember the debate as a kid, was almost entirely over whether we should have affirmative action for African Americans and the slots would be in practice taken from white students. But since then, the United States has grown much more ethnically and racially diverse. 25% of the population of 18-year-olds in the United States checks off the, identifies as Hispanic, only 15% African American, and Asian Americans are now about 7% of the population compared to less than 1% back in the 1970s. This really complicates the debate because most people who are benefiting from affirmative action are not African American, they're Hispanic, and not everyone who's Hispanic is non-white. In fact, I always, whenever the DeFunis case comes up, I learned something very interesting in researching my book, which was that DeFunis himself was Jewish, but wasn't just Jewish. He was a descendant of Jews from, was it Greece, somewhere in that region, the former Ottoman Empire, and his grandparents were Ladino speaking. In other words, they spoke the Spanish Jewish dialect that Sephardic Jews had inherited. So but at that time, they only had a Chicano classification, a Mexican American, not a Hispanic classification. If we were having a DeFunis today, he'd be on the opposite side of the case, because if he checked the Hispanic box, which he'd be perfectly entitled to do as a Sephardic Jew, he would actually be potentially a beneficiary of the preference rather than on the other side of it.
Stop you there so we can give Mike an opportunity to make his opening remarks. I just think that last bit shows you how confusing these classifications are, and even the statistics that you shared with us were like, based on what, right? On whose classification? Mike?
Good to see all of you here today. Must be either the pizza or my colleague making it extra credit for some of you. But it is good to see you here. Sure, absolutely. Can everybody hear me now? All right, Jill, great to see you as well. As mentioned, I hired Jill actually in that spot. As Dean Weiss would tell you, there's always a lot of headaches being the dean, but I never worried about LCDO at all, Jill. So great to see you, especially off the jogging track, right? Look, it's an important topic we're here to talk about. Equality in the Constitution, how we define equality in a society that has some difficulties with race. And I think it's important not only to define it, but it's important that it's in the Constitution. It should have been in there in 1789 after the Declaration had a self-evident truth about equality. It wasn't in there until 1868, but it's important to define it in 2022. I want to talk about three things, and I'll try to make it fairly quickly, but three things that I think are important for this discussion. One is history, and I'm delighted that Sheldon was able to give you some of that history on the affirmative action cases, starting with DeFunis, and I'm happy that Greg was able to reference some history as well. I think is very important to know our history. Quite frankly, to talk about affirmative action today, if you don't know our history, it makes no sense whatsoever. If you came down from Mars in 1868 and you looked at our Constitution, you would have said these people are nuts because they're outlawing something that didn't exist. And that, of course, was slavery, which if you look at the Constitution up until 1865, slavery didn't exist. So that's why I'm delighted that people are talking about our history, because it makes no sense whatsoever to talk about affirmative action without talking and understanding that history. The first reference to affirmative action, I think some of you will be shocked, 1883, Supreme Court, civil rights cases, great name for a Supreme Court case, right? Supreme Court Justice Joseph Bradley, in striking down, in a 7-1 decision, in striking down an anti-discrimination law that was prohibiting discrimination against Blacks on the train and in education and in public accommodations, Joseph Bradley said, and I quote, "At some point in their elevation, Blacks should take the rank of mere citizens and stop being the special favorite of the laws." Now, when I read that to my students in con law and race and the law, they start giggling because they say, what, Joseph Bradley, what's he talking about? Blacks being the special favorite of the laws. He's talking about the 13th and 14th and 15th Amendments, which the great dissenter in the same case, Justice Harlan, said, Blacks aren't trying to be the special favorite of the laws. They're trying to get to mere citizens. They're trying to get what everybody else is getting. And that's why we have the 14th Amendment. So we need to understand our history. And I think it's very important that I remind you of that history so you understand why we're talking about affirmative action in 2022. Second thing I want to make a reference to, inconsistency. There's a whole lot of inconsistency. I mean, I listened to Sheldon's presentation on affirmative action, and, I'm thinking I'm Ronald Reagan running for president in 1980. He said, here we go again. And I keep listening to these cases and I'm like, here we go again. It's the same deal. It's the exact same kind of stuff that's being raised. And my concern is, and I'm not great at math, but I can count to 5. I can count to 6. And all you got to do is look at the litmus test that some of the Republican presidents had. You got to be against abortion and you got to be against affirmative action. I know where Alito stands. It was all clear in the confirmation discussion. So this is not something that was hidden. Everybody understands where 5 or 6 justices stand. Greg said he's confused about what Justice Thomas was asking. Look, I'm just going to be candid with you. I got tenure. I'll say what I want to say. Justice Thomas confuses himself. Let's be real clear about that. He's the lost justice. I tell you, I don't know. Let me say one couple other things about inconsistency. I think Kavanaugh was teaching at Yale, not Harvard, but I'm not sure. He
went to Yale.
Both.
He went to Yale.
He went to Yale. He was teaching at Yale. Maybe they fired him or something. They did. All right. I have to check that. But when I was a 1L at Yale, I was sitting in a room just like this having lunch, sitting down with some of my classmates, having good discussion. And one of my classmates, white fellow, he said, look, I got 800 on the LSAT, 4.0. Had a couple other friends that did too, and they're not here. And he said, look, we got 11 Black students out of 175 in the entering class, and I bet none of them got the 800 on the LSAT and the 4.0. And he was upset. And my response to him was, don't be upset at me or some of the other Black students here, because 25% of the class are legacies. I said, if you want to be upset with me because I'm a legacy. That's how I got into Yale Law School. I understand that. I had a preference because my uncle went there. So I said to him, don't be upset at the Black students. Why don't you think about the 25% legacy? Now, when you look at the arguments that were raised by some of the justices, Justice Ketanji Brown Jackson raised that argument. She said, I don't understand why you can have a race, you can have a preference on veteran status and a preference on physical handicap and a preference on your parents. And you can't have the same kind of a preference on race. This is something that we all need to think about. Why is race being looked at this way when we have a whole lot of other preferences that nobody's even questioning? People looking around, oh yeah, that's okay. That brings in more money for the school. So what's wrong with a parental? What's wrong with a legacy preference? But race, you look at the voting rights cases, the Supreme Court has the same sort of thinking. They say, oh, you can use any factor you want to draw a congressional district. Any factor you want. You want more Democrats, fine. You want more Republicans, fine. The only factor you can't use, race. Why not? Because Justice Kennedy said that would be like having apartheid that exists in South Africa. That would be like having apartheid in America. So we can't have race in drawing districts. We can do it on any other level. So here's what I'll finish up by saying, Jill, so we have some time. You can disagree on a whole lot of things about affirmative action, which I'm sure this panel will do, and which I'm sure many of you will do, just like the Supreme Court does. But whether you say, hey, look, affirmative action hurts the recipients or affirmative action is helpful, one of the things that is clear is affirmative action is effective. You want to talk about diversity, which Thomas says he can't define, and the lawyers seem to have had trouble defining it. You want to talk about creating diversity. Affirmative action has been very effective in reducing racial isolation and in bringing about some inclusion. So we can discuss, does it hurt the recipients or help them? Does it make other Americans who aren't part of it, does it make them hostile? And you know what my response is? There was a whole lot of hostility before anybody even thought about affirmative action. You want to understand what created the hostility, go back to the history and look. It wasn't affirmative action that created the hostility. So I don't think affirmative action today is what's creating the hostility. I think there's something else. I want to know why Abigail Fisher, I want to know why Barbara Gruder, who I want to know why those two, and I'm trying to think of the young lady I debated 10 years ago.
Jennifer Gratz.
Jennifer Gratz. I want to understand why they didn't sue the white students, or they didn't sue the university because of the white students that had lower grades and test scores that got in. All you got to do is look at the cases. There were white students that got in with lower test scores, lower grades, but they didn't sue the university over those individuals getting in. Why not? There's something seems to be special about race. And so when you want to think about Justice Bradley, saying Black people need to stop being the special favorite of the laws. Think about why race is being treated so differently today when it might be used to benefit, to provide some equity, to provide some remedy. And you want to talk about why diversity is being focused on? It's because the Supreme Court said you can't use offsetting historical discrimination to deal with the present inequities. The inequities are still there. I wrote a book called Ghosts of Jim Crow. It talks about the inequities are almost as bad today in terms of segregation of our schools, in terms of the socioeconomic index, which has tremendous disproportionate impact. So the disparities are still there, and we need to correct them. And so what I would ask any opponents of affirmative action, what's your solution to correct the disparities? Or is this simply to say what was done in the past was wrong? We regret that, but tough luck. Nothing else can be done.
Segue into my question, which if we could channel the lost justice for a moment. Let's say diversity isn't the compelling state interest, but equity is the compelling state interest. Is that a compelling state interest, Greg?
I think equality is a compelling state interest. I don't know what equity really means. Every so often I see this Facebook meme about somebody looking at a baseball game and stacked on boxes, to which, of course, being a property person, I respond, they should have paid for the ticket to begin with. They should not be watching the game for free. I guess what I would, in some sense, I want to respond a little bit to what Sheldon said, or to Mike said. I agree in some sense with both what was said, that one of the reasons race is being used is because there are legacies. And because, as I think Justice Gorsuch pointed out, Harvard really wants squash players. And because Harvard wants people who scored like 800, whatever the score is now in SATs. But it seems to me that you can't allow university to, nobody forces Harvard to come up with its own academic criteria, right? Harvard can admit everyone or no one, or do whatever it wants. It doesn't have to have a class of only 1,600 people. But it seems to me, at the very least, odd to tell a university like Harvard, saying you can set up whatever criteria you want, completely up to you, then recognize that your own criteria are racially problematic because of legacies, because you're trying to recruit people who do crew, who tend to be mostly white, and then to remedy your own criteria, instead of rethinking them, say we're just going to then consider race. That seems to me weird, as opposed to saying well, maybe we shouldn't give preference to legacy. Maybe we shouldn't give preferences to donors. Maybe we shouldn't recruit crew players. At least start there before we say no, we're gonna have those criteria, and because we ourselves screwed up, we're gonna fix it in this kind of odd way.
My response to that is we can get rid of legacies. We can, because you're referring to the argument that Justice Gorsuch brought up.
Right.
He said, well, what if we just got rid of legacies? We got rid of, so you wouldn't be able to get in money for Art Institute or Art Museum, and we got rid of the squash team. We can get rid of all those things. And I would say that we still need to have affirmative action, because what measures are, schools have to use some form of measures. They have to use some form of assessments. And my question to you is, what assessment can people use that is not biased by race? We live in a society that is structured by racism. Name a measure that's not tainted by race. And if you do, then I'm like, yes, let's use it. But the problem is they don't exist. So what we have to do on some level is to have some reflexive practice where we realize, look, the things that we have, they're not perfect. Now, I'm not saying let's get rid of the SAT, let's get rid of grades. The measures aren't perfect, but let's realize that they're not perfect. Can we come up with some way to think about how to acknowledge the bias and then correct that bias? Now, that's not the argument that's before the court, unfortunately. Unfortunately, I agree with, I think, everything that folks have said, that it's kind of sort of a clown show that we're witnessing right now, where everything is focused on diversity, which commodifies Black and brown bodies, I think, in really weird ways. It says that, the reason why we need to have Black and brown students is not because it's fair, but because it makes a better product. I think there's a problem with that. But yet, that's the door that's the window that was cracked open with Justice Powell. And that's what everyone's been arguing ever since. But people are not focusing on remedial arguments or equality arguments. And I think that, the conservative justices, I believe, are concerned with equality on some level, because you have Justice Gorsuch who's saying, hey, let's get rid of these legacies. But the problem is that they're not extending that equality rationale even further to think about, well, how do we really think about making this entire process more fair, not just for white students, because that's what they're concerned about, how to make this process more fair for white students, but how to also make this fair for people who have been disadvantaged for the last, couple of centuries.
Incredible, and we're getting so close to the end. I really want to make sure that we give time to the audience to ask some questions and then give our panelists an opportunity to maybe give a couple of predictions before we close. So let's turn to the audience for your questions. Could you stand, please?
Yeah, I guess. Hi. I actually have almost like 3 questions, and one specifically for Liz. And so
I appreciate my name pronounced with the right Russian accent.
well, so we're talking a lot about these factors that are embedded in everything in life. Everything, like get rid of affirmative action doesn't matter because everything you said is still embedded with race and racism. But I also want to point out that we've been talking a lot about identity. And right now, law schools across the country who are not in the top 15 are at the mercy of the U.S. ranking system. We see it in our hiring practice. Every single one of you comes from an amazing school. That's not a negative thing, but what happens is without this action, without actually looking at all these factors and how they're actually placed in this role, what are we gonna do? We can sit here and talk about Harvard, but how can we evaluate our role in that system as well, and the U.S. ranking system? And then so I would love for you guys to respond to that more, and like what that means for you with your place in this, like in our school where we are more at the mercy of those things because of money, funding, and all that stuff. And then I also wanted to have you guys talk about how affirmative action and how the conversations existed are identities that are categorically related to like geographic relationships and religious relationships. And I was thinking predominantly about how there are a lot of countries that were part of the Soviet Union with like, this is where my identity comes into play, where we have immigrants that do identify as brown who do in the US, they would be treated the same as brown individuals, but we also have a lot of white individuals like myself, and how geographic relationships view the narrow checkbox. Like, what do you put down in your geographic space is not indefinite.
Well, I'll leave the second question to David. I think, again, he has a whole book on it. But I will say that I take your point even on that. It's been really weird coming to America, where in the Soviet Union, I was a Jew. I came to America, I became a Russian. And in the last, like, 5 or so years, I became a Ukrainian. It is, and I haven't changed, right? It's this kind of the idea. It's very odd, right? And so for example, people say like, well, what's your ethnicity? When I came here, I tried to respond, well, I'm Jewish. They're like, no, that's religion. I'm like, not where I come from. That's very much an ethnicity. But so I think I take the point that it's hard to figure out, like, because each one of us has multiple identities, right? Where we grew up, what color our skin is, what our religion, etc. On the first point, I think you're right that we are focusing on these elite institutions. Although I think they're also very much concerned about U.S. News World Report. Every one of the reasons, for example, I don't know if any of you read David Latt's blog. One of the reasons he focuses on Yale, not only because he went there, but because Heather Gerken, the dean of Yale, she's absolutely petrified that next year Stanford will be #1 and not Yale. So they're equally at the mercy of this. But yeah, no, it's weird, right? So it's interesting that we're focusing on these very elite institutions, And so, but that raises a serious question as to what is the Harvard's interest? Is it diversity? Or is it diversity within the context of being very exclusionary, right? Harvard could be more diverse, and I'm not saying necessarily even lower the standards. You can increase the class size, right? You can do all sorts of things, but Harvard doesn't want to do it. In fact, there was a funny moment at all arguments when I think the attorney for students challenging the Harvard admission said, like, look, we're not trying to make Harvard a community college. We're just simply asking Harvard to become Dartmouth, right? To go from 99% to 98th percentile, right? And Harvard doesn't want to do this. And you should ask yourself, well, what does that mean? Do we want institutions that have potentially the superficial level of diversity, but exclude 99.5% of basically applicants? And also self-excluding because a bunch of people don't even apply, right? And does it all trickle down? So it's an important question.
Okay, me. All right, so there was a lot to unpack there, but I'll focus on the classification issue. So there's it's really one of the odd things about the way we do diversity in universities, again, looking at the Common App, is they give you these boxes to check. And for the most part, they don't give you any definitions. So if it says, are you Asian? You may think if you're from the former Soviet Union, but from one of the Asian republics, you are Asian American. But actually, if you knew what the official Department of Education Office of Civil Rights definition is, they do it by the country that you were in when they made these classifications in the 70s, which was the Soviet Union. And you are indeed not Asian if you're from one of the stands, as they say. You are officially white. But that goes again to a broader question. I mean, I understand advocates of affirmative action don't really want to revisit the classifications because affirmative action, in a sense, is hanging by a thread, and if you start unraveling it, you might just lose it. But in some sense, if you are in favor of affirmative action for the reasons that some of my colleagues on the panel suggested, you really do need to start rethinking them. In the university context, it's already a little strange because a lot of the students who are getting preferences who are quote unquote African-American, that's controversial what that should mean, but in the context of preferences, it turns out that a wildly disproportionate percentage of the students who are getting benefits at schools like Harvard are first or second generation African or Caribbean immigrants, often from relatively well-off families, and that's not what the original intent was. But the even stranger area is minority business enterprise programs, where there's tens, maybe hundreds of billions of dollars at stake in annual government contracts. If you get certified as a minority business enterprise owner, it's, depending on the state and so forth, either easier to get a contract or some contracts are set aside or whatever. And in that context, unlike in admissions, there's no distinction between the different minority categories. So it doesn't matter whether you are, whether you came from India 6 years ago to get a PhD at MIT and now you've started a construction company or a technology company, you want a government contract, or whether you're a descendant of 8 generations of Americans who've lived here since slavery times, or whether you are Hispanic or whatever else, you get exactly the same preference. And it's really hard to get any data on this because no one wants to reveal it. And I tried to get this data just out of curiosity. And I was told by people in the Department of Transportation that no one will ever give this to me because it'd be too embarrassing. But I doubt, from the limited data I've seen, I doubt even 20% of the contracts that are going to minority business enterprises are going to African Americans of any background. And indeed, there was something of a mini scandal even 32 years ago in Washington, D.C., where 90% of the contracts for minority business enterprises in Washington, D.C. were going to 3 Portuguese brothers who owned a series of interlocking companies at a time when Washington, D.C. was 60% African-American. So these classification issues are really important, not simply because they may make affirmative action coherent and then may make you more skeptical of affirmative action, but if you are an advocate of affirmative action, you have to say, what were we trying to accomplish with these classifications, and are we actually still accomplishing it today, given the way our increased diversity has undermined some of the original purpose?
All right, we get,
Up to weigh in on.
sure,
on-
sure. And then we're going to do a lightning round of predictions.
Oh, okay.
Because I think people have
Well,
class.
just to weigh in on 2 things. One, the classifications, the racial classifications. I agree with some of the concerns of the panelists that our classification system has been a little bit arbitrary. That to me doesn't say we need to stop affirmative action because there's a justification independent. Let's get the classifications right. Let's come up with some definitions and get them right. And the thing is, in 1896, in the Plessy case, Homer Plessy's lawyer argued the same thing. He said, hey, the racial classification setup is arbitrary here. And we've had interracial mixing in this country for many, many years. And it got real tricky for Louisiana and for Alabama and for Mississippi to figure out who was white and was going to get the goodies under their setup and who wasn't. But guess what? They did it. So you know what? I think maybe we can do it. With respect to your other question about the elite schools, look at the Plessy case. The elite schools, Harvard and Yale, got it dead wrong. Justice Harlan, the only dissenter in the case, 50 years later, 9 justices say, Harlan, you were right in interpreting the Constitution, and he didn't go to an Ivy League school. So what I tell my students at UB, get it right. Get it right. That's the answer. Get it right. Be on the right side of the issue. Be on the right interpretation of the Constitution and make those Ivy Leaguers look foolish, or make your Ivy League professors look good.
They don't need any help on that.
Let's do our predictions quickly. Where do we think?
Oh, well, look, I can count to 5 and 6. So, you know, if you look at what happened in Dobbs, which I taught last night, I think they're going to do a repeat, nothing but a rerun. They're going to strike affirmative action down. They're going to use the same weak, inconsistent reasoning and excuses they did on Dobbs. And unfortunately, we're going to have to get this panel back to come up with something to do about the continued disparities in our country.
You know, I'm generally loath to make predictions about Supreme Court, just because, I mean, I think kind of the top level prediction, I think both Harvard and UNC lose, but I think it matters how they lose, much more so whether they lose. So I can absolutely see the court writing an opinion saying that Title VI, not the Constitution, basically kind of essentially leaving Grutter alone for now, saying whatever the Constitution might permit, Constitution kind of gives universities more leeway. Congress, when it passed Title VI, prohibited consideration of race. Much like Justice Gorsuch wrote, what is it now, 3 or so years ago, that when Congress used the word discriminate on sex, right, even though nobody in 1960s thought that sex meant transgender or sex meant same-sex relationship, said it says sex, it says discriminate. Full textualism, full stop, that's what sex means, that's what discriminate means, we're done. And I think they might take the same move on saying basically, look, although a country may have allowed you to do this, Title VI does not, simply because the word race means race and word discriminate means discriminate, and leave it at that. So that's a possibility. Whether it's a prediction, I don't know. I think universities lose, but it does matter how they lose.
Yeah, I think they're going to lose, but to me, the main issue is whether, the most interesting thing maybe to me will be whether they really focus on the issue of classification versus so-called race consciousness, because race consciousness, the 10% plans are race conscious in the sense that we recognize this is one way of achieving diversity without having to classify individuals by race. Having a preference for descendants of slaves, while it will be almost 100% people who are Black Americans. On the other hand, it will exclude about 30% of Black Americans who aren't descendants of slaves, of American slaves, at least, who came from the Caribbean or Africa as immigrants and so forth. And I think that issue, it came up in a case called Seattle School Districts about busing years ago, where the majority suggested that we're really concerned with race conscious things that have disparate impacts in some way. And Justice Kennedy, in a concurrence, said, whoa, it's okay to be aware of the social impact on different groups of what you're doing, but that receives a much lower level of scrutiny than actually telling people you are of this group and we're going to assign you to a school based on that designation. So I'm looking for any hints of whether Kavanaugh brought that up, of whether the justices will tell state universities and potentially private universities, you can be race conscious in how you make your policies, but we are not going to let you classify by race.
I really appreciate, Greg, like your distinction with your prediction on the Title VI versus
Not prediction,
but comments about the Title VI and the 14th Amendment, and I'm curious to see if that comes to fruition. I'm in agreement that I do think that perhaps the universities lose in these cases. I don't think, based on my reading, that Grutter is going to be overruled. I think it's going to be limited. It seems like if you listen to the oral arguments in the North Carolina case, all of the justices seem to, not all, but I think a majority of the justices seem to agree that diversity is a compelling government interest. I think that they're hung up on the narrowly tailored prong of this. And I think that, and also, and we didn't talk about this, is the whole sunset provision. So there's a sunset provision that's in Grutter, well, that people argue that's in Grutter, that Justice O'Connor came up with in 2003. She says, well, you know, should we not need affirmative action in the next 25 years? And 25 years is 2028. And a lot of the conservative justices seemed super focused and honed in on that point. Like, when does this end? When does this end? When does this end? When will we know when it ends? So I think I think that the court is going to probably shut the door on Harvard and maybe UNC, but maybe leave a window cracked open. And say, yeah, diversity is a compelling government interest, but you all need to do more with respect to whatever race neutrality means. Yeah, so thinking about that narrowly tailored prong.
Join me in thanking this amazing panel